This is what you honor.
Yes.
With respect to your honor, the court is bright. You have made very bright remarks. We are in a dilemma. And the only office that could take us out of this dilemma is the office of the DPP. And I would respectfully state that we adjourn this matter at this stage. Let my able and friend, the prosecutor, go and discuss these issues, take instructions on, look at some documents and so on. She probably may come up with an answer. And if at that time she comes up with an answer that is not probably satisfactory, then what you're suggesting about putting in submissions and so on, we may have to address that. But you give her an opportunity, the DPP's counsel, to go and find out what it is and so on. On my part, I'm on dilemma. I take on the instructions from the accused person.
And this morning you took instructions on behalf of LSK before they appeared.
Your Honor, they
Yes,
were not
that's okay.
the superficial instructions.
Yes,
the
yes,
superficial
yes,
instructions
yes.
they
You
had.
represented them
And
this morning.
what he has told me superficially, it appears as if this matter is deeper than I seem to know it. And the only person who can take us out of this matter is actually the counsel for the DPP. He should go back.
I hope you've heard my sentiments. We can't tell the DPP what to do. Neither can we tell the investigators what to do. And in short, I can't cross over from here to that end. If I go that end, then I shouldn't hear the matter. So I want to remain here. Right? So that everything else is resolved by the institutions that should resolve them.
That's all.
In one sentence, I'm saying I shouldn't hear any evidence or any allegation until it is presented in a hearing. That's all I'm saying in one sentence. As a court, I'm not allowed.
No, you can't. But
Yes.
also I'm saying, Your Honor, we probably should answer, let me put it this way. Without saying much, can you adjourn and proceed?
No, I can't adjourn and leave the matter hanging.
No,
Senior
you're not
counsel.
giving it to hanging.
I'm held liable.
You're going to give us a date.
No. I won't give a date before we know what we are doing. I know it's an easy way. Let's take another date. Let's go away. You people said I'm bad. Now let me be bad. Tell me how we move forward. As we leave and take another date, who is going to do what? And the person to start us off is the gentleman, Mr. Ngara. He says he has information that he relayed in form of a letter, and according to his clients, that information was not dealt with, and at least they never received a response. That's the starting point. And if I've misquoted you, you say I've misquoted you. Right? So since all of us must access justice, all of us, let him jumpstart that process again. And let it be through a court order of this court extracted by the DR that the LSK and the brothers of the deceased to engage, I didn't say to order, engage with the investigation arm, which I assume is DCI, on the matters raised in the letter of, you give the date. Thereafter, let the same be relayed to the ODPP to consider the new circumstances as indicated in the letter of, and the defense counsel to also be part and parcel of the process.
Well, with the
It is that simple.
With the respect,
Then each institution deals with the matter, and once they are through, we proceed with cross-examination of. And don't say anything that
I'm trying.
Yes,
I'm trying.
I know. Even the letter, don't mention
Yes,
it.
the
keep
DPP.
trying.
Yes, the DPP. The former and present are aware of this matter,
Yes.
and our instructions are still the same, to proceed with it as it is.
Okay.
The victims' councils say they have information that they have not provided to us.
Yes.
So the correct position on our side would be for them to go and record this information,
Yes.
so that it now can be brought onto the file,
Yes.
because it would be unfair for the victims to now question anyone or for them to raise any issues on the doc. That because if there is issues on the doc and it's not part of our statements, we then have an issue of we are raising information that the defense does not have, or even we don't have. So if there's information that is present,
That's correct. Yes.
it should be recorded and submitted as a statement. Because we are also not aware, because we only have the statements on our file, and that is how the decision at present
Was arrived at.
So any information that they have should be recorded in statement form by the investigative officer.
Okay.
So my wish would be that we proceed with this witness, because she has come here, I think, 3 times now. But I also hear the victim and the defense counsel all saying that they need time. That is what I'm hearing. But my issue would be, we also need to consider the victim's position. One of the victim's position. She's been here.
I respect the fact that we ought to proceed with cross-examination. But this is the dilemma. I have the question, what if?
Yes, my lady.
Because we don't know what cross-examination will entail. We don't know whether it touches on the information that the party indicates has not been addressed or has emerged since then. Remember, this is an old matter.
Yes, my lady.
So matters continue to evolve. We don't know.
Yes, my lady.
And then we also don't want to proceed with cross-examination, then say, by the way, and we will want you to come back on another day.
Yes, recall.
Again.
That's right. That's
Yeah.
correct.
So allow me to just, unless there's something I've left out, Mr. Kago, I'll hear your position. Then I record what I have said. And we give this quite a while. You have enough time. When we resume the next term, what I want to hear is that we are proceeding, whatever the outcome is.
Okay.
All right?
Yes, my lady.